Good morning, everyone. Thank you for your little chats in the bottom there. I think we'll go ahead and get started. We do have well over 100 folks joining, but in honor of time, like I said, we'll get going. So thank you for joining. My name is Lisa Albrecht. I am PMAR's 2021 VP of Professional Development. It's good to kind of see you all, I guess, today, and hopefully in the future, we will see all of your faces again in person. PMAR has worked hard this year to offer tools and resources to help you with your business. I hope you've taken advantage of more than 35 classes and programs scheduled so far this year. We couldn't do this without the support of our annual partners who offer a wide range of services for our members. I would like to recognize them now. We do have a video coming here, just bear with us.
Experiencing a little technical difficulty here.
Yeah, so give us a second. It's going to pop up. We want to just give a shout out to those partners who have supported us. And we are watching the chat button down below. So love to see all the good mornings and the welcomes. So thank you for that. And as we progress through the meeting, feel free to continue to use that chat button for questions and comments and all those things. Hello from Astoria, Carrie, good to see you. I know that several other people have said good morning, and I want to acknowledge you as well. Oh, and it looks like we're going to move in and out of a couple screens here to kind of reset in the background. So bear with us. Mary Jane's doing a great job here, and she's going to get that video going for us about those annual partners. Hi, Jen. Good morning. And Carol, you had a question about the credit hour, about 1.5. I believe it's only a 1 hour credit, just to clarify that. Good morning, Diana. And good morning, Helen. And good morning. Thank you, PMAR staff, Whitney, and all the folks in the background at the PMAR office. You've done a great job helping us today. Good morning, Ellen. I might actually, good morning, Jennifer. Kathy, can you pop in and give a shout out to our annual partners here a little bit? Maybe we can just give a voice in the background to the video as Mary Jane continues to try and set that up.
I got it right now, actually.
Oh, here we go. Thank you, Mary Jane.
Behind every great realtor association are the partners who support your business and the industry. Check out the incredible PMAR partners supporting you this year.
Wonderful. Thank you again, partners. We appreciate your support this year. So we're going to move on now. We have an important and timely program today, and I'm excited to share it with you. Before I introduce... Okay, we're going to pause a second. It's trying to take us to our next video. So Mary Jane's going to pause that for a second for us. Before I introduce the program, I have the privilege of presenting our Future First Citizen and Good Neighbor Awards today. Usually these awards are presented at our First Citizen Luncheon, but due to COVID, we had to postpone the banquet. So we recognize those two individuals who have dedicated themselves to improving our community today. And we're going to start off with our First Citizens Award presentation. This award is the Portland Future First Citizen. PMAR created this award to honor one high school student in the Portland metropolitan area who is a model of civic responsibility. The 2021 Portland Future First Citizen is Benjamin Olshan. So we want to congratulate him and give him an applause today. So give a little shout out in the Zoom to him. In 2017, Benjamin founded Babies with Books. It's a teen-led program where volunteers work with families that have newborns in the NICU and provide them with books to help read to their babies. And please enjoy this short video with more information about that. Congratulations, Ben. What a great video on your community work. Unfortunately, Ben couldn't be here today, but on behalf of PMAR, it is my honor to present him with the 2021 Portland Future for Citizen Award, along with a $5,000 scholarship for his continuing education. A plaque is being mailed directly to him. We applaud Benjamin's commitment to the betterment of our community and encourage him to continue his efforts. Great job, Benjamin. And with that, we will move on to our 2021 Realtor Good Neighbor. It is my pleasure to recognize our Realtor Good Neighbor. This award was created to recognize and honor realtors in the Portland metropolitan area who are contributing significant time, personal resources to improve the livability of our communities. On behalf of PMAR, I am honored to present this award to Lynn Brokaw with the Hassan Company. Thank you, Lynn. For almost 30 years, Lynn Brokaw has been a dedicated volunteer and supporter for the Lake Oswego Meals on Wheels. And here's another quick video about his services in our community. Enjoy. Thanks everyone for congratulating Lynn down in the comments. We love seeing those down there. So Lynn, on behalf of PMAR, I present you with this award and a $1,000 contribution in your name to Meals on Wheels. A plaque is being mailed to you directly in honor of that. I know everyone joins me in thanking and congratulating you for your outstanding commitment to enhancing the quality of life in our communities. You truly are a realtor good neighbor. Lynn, if you'd like to unmute yourself and provide us with a few comments, we invite you to do that now. We'll give a couple seconds here. Thanks everyone again for congratulating Lynn in the comments. It's so exciting to see him given this way and seek donations. So it looks like Lynn is there, and let's see if he unmutes so that he can say a few things about his award. Lynn, are you shy today? Okay, I'll give you a couple seconds more. We're seeing these fun comments below dedicated to you. Thank you, everyone. I don't know if Lynn's having technical difficulties or not. I would love to hear him talk a little bit. I'm sure he has lots to say and how we can support him and the Meals on Wheels program. A lot of great information in that video. Again, this is recorded, so if you wanted to share and go back and see more information about how you can help him in the community, we will be sending this out later. And it looks like Lynn is going to stay quiet today. All right, that's all right. So we're going to move on. We know you, our Realtor members, are making a difference across the metropolitan region. So thank you for making our community a better place through your volunteer work. So share your story, share your photos, share your good neighbor story. If you volunteer, please share the details with us or tag us in your social media posts. We're always looking for great stories to share. So thank you to everyone for your giving and making a difference in our little bubble here in the Pacific Northwest Portland area. Again, my name is Lisa Albrecht. I'm the moderator today. I'm PMAR's Vice President of Professional Development, and I am a broker with Premier Property Group. Before we move on, I wanted to highlight one note. Oh, Lynn, his microphone did not work. Lynn, would you like to pop in now? I'm happy to pause and give you a moment to speak up. If it's still not working, give me a little note in the chat section. If it is working, we would love to give you that opportunity to chime in about your award today. Okay, looks like your microphone is still being ornery. You just keep me posted and we'll just move along. And at the end, let's see. Okay, we're going to move on. So before we go on, I just wanted to highlight one more note about the credit hour today. In order to receive your certificate for the 1 hour of continuing education credit, you will need to go and fill out and return the attendee attendance form that was emailed to you this week. You must be present for the entire presentation in order to receive that credit. Attendance forms are due by the end of next Thursday, October 7th. If you don't receive that attendance form, please feel free to reach out to Mary Jane Mansfield. Her email will be in the chat. And I see that Lynn did want to speak up, but unfortunately his microphone's not working today. So if you know Lynn or you wanted to reach out to Lynn, I'm sure he would love to hear more praises and congratulations for him. But again, a great way to support him is to go and look into Meals on Wheels. With that, I'm excited to move on to the main part of our program today, and that is the Realtor Rap Sheet. And basically we will move on to the next slide here. It is basically we're going to follow one real estate transaction that's gone awry, resulting in 5 separate complaints: an ethics complaint, a complaint of misuse of a lockbox, a buyer and seller mediation, and 2 related complaints filed with the real estate agency. All the scenarios are fictitious, but they teach us and touch on areas where we frequently have questions and complaints. Feel free again to use the chat section if you want to chime in about this, these 5 complaints through one transaction, or ask your questions there. So we have 4 expert speakers who will walk us through each scenario, and we'll ask you to be the judge in an online poll as we go. We'll be sharing information about the processes at each organization, as well as historical statistics and how sanctions are determined. Our goal for your takeaway today is that you have a better understanding of various ways a realtor can get into trouble and how the systems work to enforce standards that enhance our public and professional image. Our first presenter is Mary Williams, this year's chair of PMAR's Professional Standards Committee. Mary is with Berkshire Hathaway HomeServices and has been a realtor for 30 years. So please welcome Mary this morning. And Mary, I'm going to let you take it away.
Thank you. Good morning. It's actually been 43 years. I'm sorry to say. I'm sure 13 when I started, but it's been 43. Hey, good to be here today. I think we're going to have a really interesting presentation because the rap sheet for this is very clever. I kind of wish I'm not clever enough to make up all this stuff. So kudos to whoever figured out how to wrap 5 issues into one. So what we're going to do is I'm going to handle just the ethics part of it. I'm going to read you the dilemma. I'm going to read you the article, and then we'll have a little bit of discussion, but then you'll get to vote on are they guilty or not guilty. So this is definitely participatory. So we'll start with the first complaint, and which is ethics. Realtor Dottie listed a property that she knew would be perfect for her son, Oscar, and mentioned this to the sellers. She immediately showed the property to Oscar, wrote a full price offer, and disclosed her relationship in his offer to the sellers. Dottie and the sellers agreed to wait until after the weekend to consider all offers. Numerous offers were received, but the sellers accepted Oscar's full price offer because it waived all contingencies, including the contingency of a home inspection. Dottie's principal broker replaced her as the seller's agent while she represented her son. Dottie knew the sellers were out of town for the weekend when she opened the home for Oscar and a kitchen remodeling contractor. Trusting Oscar, she left for an appointment and asked him to secure the property when he left. Noting the contractor's name on the truck, the neighbor ventured over to get his business card for future work on his own house. Thinking the son was a realtor, he also asked for his business card. Oscar said his mother was the realtor and had let him in the house to get an estimate for remodeling. While talking, the cat ran out through the open door and could not be found. Upon returning, the sellers went outside looking for their cat, and their neighbor relayed what happened. The sellers found their cat and filed an ethics complaint against Realtor Dottie, citing Articles 1, 3, and 5. So we're going to address those in their order. So Article 1 is, when representing a buyer, seller, landlord, tenant, or other client as an agent, realtors pledge themselves to protect and promote the interests of their client. This obligation to the client is primary, but it does not relieve realtors of their obligation to treat all parties honestly. When serving a buyer, seller, landlord, tenant, or other party in a non-agency capacity, realtors remain obligated to treat all parties honestly. So here's the question. Did Dottie violate Article 1 when she let her son and his contractor into the home without the seller's permission? Does it matter that she was no longer serving as a seller's agent? And was she protecting and promoting the interests of her client? Does it matter that the sellers were able to find their cat and weren't harmed? We're going to conduct a quick poll here because there's a lot in here. Is there anything in there that Dottie was guilty of? Let's see. Go ahead and vote. I think they're just giving us a few seconds to get all the votes in. And it's a very interesting situation. You can kind of see with the ethics dilemma that there are a number of issues wrapped up in this this issue. So this event. So where are we? 82% said she was guilty, and 18% she was not guilty. I wonder if there's anybody who can we get somebody to speak up and tell us why she was guilty or not guilty? Is that possible, Lisa?
No.
I don't, so we're seeing a lot of comments in the chat section. So Mary, if you go ahead and pop open that chat, you'll see some comments made by folks, and maybe you can just use your voice to speak to their comments down in the chat.
Oh, good. Okay. Let's see where we are.
And you can scroll up and down to kind of go back a little bit in time.
Yeah, I'll do that. Okay. And there is a link in here also for the actual code of ethics. So if you want something to refer to, although we don't have a whole lot of time at each of these votes, that would be a quick reference. So Gary Majors, guilty of other articles, but not one. Can you tell me why, Gary, she's not guilty of one? Gary, are you there? Okay.
I think he's just making a general comment, Mary. And so there's a lot of other folks kind of interacting.
Oh, it doesn't pertain to this article. Okay, right. I see. Interesting. Okay. So, okay, that's fine. And then Alessia said she should have obtained the permission to enter the premises, but I think that's going to come somewhere else. She was in the house without permission and trespassing. She wasn't the seller's agent, as so needed permission. Okay, so yes, there are a number of different violations wrapped up in this. The lockbox will be addressed later. The standard of practice 16-16 is sellers shall not access or use or permit or enable others to use listed or managed property on terms or conditions other than those authorized. So she was found guilty of this article. She was found guilty. Okay, then she was also shown, she was also accused of violating Article 3, which is realtors shall cooperate with other brokers except when cooperation is not in the client's best interest. The obligation to cooperate does not include obligation to share commissions, fees, or to otherwise compensate another broker. If you have a second, you might want to quickly look down the standards of practice. This is kind of a trick question. So let's take a vote. Let's take a poll. Who thinks she's guilty, who not?
And as we're waiting for those polls to come in, thank you everyone for participating. We do acknowledge that, yes, your mics are muted, and so you would not be able to speak during this session, but we are watching the chats down there. So thank you for engaging that way. And thanks, Mary, for guiding us through these different articles.
Sure. So we have Article 3, we have 38% guilty and 62% not guilty. And what's interesting about this one, and why I say it's sort of a trick question, is that the standard of practice, Article 3-9 says, realtors shall not provide access to listed property on terms other than those established by the owner or the listing broker. It's interesting to me that this standard of practice was included in the article that when you just read the article, it's about compensation. And primarily. And so it is kind of a trick question, but she was found guilty on this one as well because of standard practice 3.9. Okay, let's see. Article 5, finally we get to Article 5. Article 5 reads, realtors shall not undertake to provide professional services concerning a property or its value where they have a present or contemplated interest unless such interest is specifically disclosed to all affected parties. Let's see your votes. Okay. Well, 60% said not guilty and 40% said guilty. She was found not guilty because she had put in writing the disclosure that she was related to her son. So that's why that she was not guilty on that one. So Lisa, I'm going to send this right back to you and we'll move on to some more fun stuff from this complaint.
Lisa, you're muted.
Gosh, you'd think I'd have this down by now. We've only been doing it how long? So thank you for the call out, Mary Jane. So Mary, did you want to go into a little more about the sanctioning guidelines? And then did you want to talk a little bit more about these slides before I moved on? Okay, well, there's some great information here to kind of summarize how the guidelines are determined for this, the nature of it, the harm of it, some great information here. So how much experience, so here's some thought processes for all of you to think about regarding the complaints. So take a minute here and we'll let you all read through that just to kind of expand our understanding on complaints number 1. And let's see.
I'm sorry, I lost you for a while there.
That's okay. So I was just going over some of the sanctioning guidelines, and then I know that there's some disciplinary actions that were imposed. Did you want to, Mary, go into a little more about that? So this slide will move forward to actually the sanctions that can be imposed.
Yeah, I think we can go on to that slide.
There we go.
Because those sanctions are going to sort of be that they're going to relate to all of these issues, right?
Good call out.
I mean, the 3 that we just dealt with. So there are options for sanctions. So what do we do to handle this when someone is guilty or found guilty? We have lots of options, and I said slide up. I don't see it.
Yes, it is. Great. It starts with the letter of warning. There could be a letter of reprimand. I'll just continue. Okay, I'll read these off, Mary, and then I'll pause for each one, and you can provide comments. So
there it is. I got it. Okay,
great.
Okay, thanks. Sorry. All right. So yeah, number 1, first offense, sometimes just a letter of warning. But we look, it's a lot of things are taken into consideration in these sanctions. How long has someone been in the business, and have they violated this before? Is this a trend for them? So when we're at the end of an ethics hearing, we have lots of options about how to move forward or some sort of sanction or disciplinary action for people. And it is a number of them. And so if, there'll be if someone has violated something more than the same article more than once, then they're going to get something more than a letter of warning, or probably even a letter. They'll get something more than a reprimand. So we just look at these. So yes, we can get a letter saying, hey, you can't, first one is, hey, you shouldn't do that, and we're warning you that we'll be on this if this happens again. Second one, then there's a written letter that says, hey, this is not okay, and we're more strongly saying we're reprimanding you for it. If the requirement to attend, we can also say education is a big deal. So if you don't understand ethics, then yeah, we could require you to do an ethics training. We can fine you. The committee could fine you up to $15,000, and we could even suspend your membership for a while, but not less than 30 days and not more than a year. And we can say, I'm sorry, you're just not living up to the code of ethics, and your membership is over. At least you can be expelled, so you can't do anything for somewhere between 1 and 3 years. We can suspend your MLS membership, and we can ask you for a $300 administrative fee. So there are all kinds of things that play into it. This year, in some of the ethics hearings that we've conducted, there's more than one sanction. So I think, do you want me to, shall I turn that over now?
That's great, Mary. I'll take it from here.
Okay.
So when we look at the statistics of ethics, we're going to go back in time between 2020 and 2021. And this graph illustrates the number of articles that were cited in 27 ethics complaints. So keep in mind that this chart just shows complaints that were received since 2020. So what are the most frequently cited? So if you look at this pie chart, the blue section of the pie chart represents 31% of the complaints, which is article number 1. So protect and promote the interest of the client, treat all parties honestly. So that was 31% of them. Moving down to the bottom, you'll see the gray portion of the pie chart. That is in violation, or a complaint rather, about article 3, cooperate with other brokers, for 18%. The orange section of the pie chart relates to article number 2, avoid exaggeration, misrepresentation, or concealment of pertinent facts. That was also, or that was at 13%. And then moving up to the top right, left-hand side of the chart, you'll see article 15 there, kind of in the brownish color, shall not knowingly or recklessly make false or misleading statements about other brokers or their business practices, and that was 13%. And again, these are just complaints that were filed in 2020, 2021. So let's talk about actual violations. And so this graph here represents the number of ethics violations since 2020. And so let's talk about most frequently found ones. You'll see the blue chart here, part of the pie chart. I'm going to pause for a minute. Will you be receiving a copy of the slides? We'll have more comments on that towards the end, but it is being recorded. So do indeed watch for the recording where you can take a deeper dive into this presentation again. So going back to the violations, the blue portion of the chart represents Article 1, protect, and again, that is protect and promote the interests of the client, treat all parties honestly. That was 38% of the violations. The gray portion of the pie chart references Article 3, cooperate with other brokers. It was also 38% of the violations. Any questions or anything that we can pause for a moment? I see some comments down below. There are more than one article on each. Oh, I see, Gary, what you're saying. So articles 3 and 5, yes, good call out. So we're seeing some overlapping here in the blue and the gray. So we're seeing articles 1 and 5 together being 38%. And then we're seeing articles 3 and 5 be 38%. So great call out. Thank you for correcting me there. And you can see how other articles are combining together. The yellow numbers 4 and 1, 8%. So I think you all can see those numbers there. If we don't have any more questions,
Lisa, if I'm not mistaken, I think that might mean that there were 5 cases.
You're right. Let's talk about it again. So Article 1 had 5 of the violations, totaling 38%. Article 3 was again 5 violations for 38%. So good call out. I should have, anyway, good conversation here. Thanks, folks. And with that, I'm going to turn it over to Christina Smestad, with RMLS. She is the Vice President of Operations, and she's going to go over complaint number 2 of this scenario. And please welcome Christina to the presentation.
Well, thank you, Lisa. So for complaint number 2, the sellers filed a complaint with RMLS alleging Dottie misused the lockbox key when entering the property without their permission and allowing the son and his contractor to remain in the property in her absence. So this was an interesting scenario because the question came up, does RMLS take complaints from the public? No, we don't actually take complaints from the public. The complaint would be the seller having their listing agents bring forth a formal violation to RMLS in this instance. Another question that we were talking about was, does it matter that Oscar was under contract to purchase when he visited the home that was soon to be his? And the answer is no, it doesn't matter that it was under contract. he still was not the legal owner of the property. And you have to respect the seller and their wishes during the time that they still own the property on how they want that property to be accessed or shown by anybody involved in that real estate transaction. If the cat had not been found, would RMLS have made Dottie buy a new cat for the seller? I honestly have not seen that question come up before. And the answer would be no, that's personal property, and that would be outside of the realm of RMLS. And so we have a poll, I believe, that Mary Jane is going to help put us up on the screen to find out if Dottie is guilty or not guilty of misuse of the RMLS lockbox. And I think we're going to run that for about 20 seconds or so and give everybody a chance to put in their answer. Oh, I love it, 100%. That's great. So on the next slide, we'll see that the actual verdict was guilty. That is a violation of the RMLS rules. On the next slide, because she was guilty of the misuse of the lockbox. So what we have is just a little bit of information that we've gathered about our formal violations. So we gathered some of our statistics regarding the formal violations submitted to RMLS since 2017, and are sharing the number of violations that came in and how our Rules and Regulations Committee levied a potential fine. For those that maybe are not familiar with the RMLS process of our formal violation process, we have a RMLS Rules and Regulations Violation Report number 1452 on RMLS Web. That's available for the person submitting the complaint. They would take that form and they sign it along with their participant broker and submit it to RMLS into the data accuracy department. So when we receive those formal violations from you guys, we then mail a letter to the respondent, the agent who has allegedly committed that potential violation, and their participant broker, requesting that the issue be corrected and an explanation provided within 7 days of what happened in that particular violation. Our violations in section 5.1 of the RMLS Rules and Regulations are broken up into minor infractions and major infractions. Obviously, the lockbox in this discussion today is a major violation infraction in our system. That fine, that sanction carries an amount of up to $2,500. As you can see on the screen here, we've already assessed one this year where a complaint came in and was found to be guilty for that violation, and a $2,500 fine was levied. When we get the letter back from the respondent, that information that we receive goes before the RMLS Rules and Regulations Committee. It's made up of 9 of our subscribers and one board of directors, which includes one board of director who happens to be Jeff Wyron this year. So he's the chairman of the RMLS Rules and Regulations Committee. They review the case. And then the agent and participant broker are then notified of the committee's decision. And if a fine has been levied, they're given 20 days to request a hearing. So if they don't like the outcome of the Rules Committee's decision, they can have it be presented to a hearing panel made up of different people in our process for the hearing committee. They have 20 days to submit for that request. So if the allowed time has ended without a request for hearing, or they waived their hearing, or if a hearing has been conducted and the fine has been imposed by the Rules Committee, has been ratified by the Board of Directors, the fine is assessed. So essentially the respondent has a chance to, at the Rules Committee, submit their statement about the violation. If they get a levy fined against them, they have the chance to present their case again at a hearing panel. And if they want to, they can appeal that hearing panel's decision and go before the RMLS board of directors for that final review. And then whatever the outcome is there is what happens for that formal violation. We know that the misuse of lockbox access is obviously one of the biggest things that come into us. Over the years, we have had all sorts of scenarios as a result of that misuse of violation. We know that lockbox access violations have the potential to undermine the lockbox system on which realtors depend. There's that potential for bad PR or sellers becoming more reluctant to utilize a lockbox system in a marketplace, making it more difficult for real estate transactions to occur. So we take these very seriously. A couple examples that we've actually run across over the years of misuse of a lockbox is when a subscriber loans a lockbox access device or code to a fellow agent, or they loan the lockbox access device or code to a member of the public, or they open a property for a non-device holder and leave them in the premises. We've also had examples of theft occurring or gaining entry into the premises for reasons other than real estate business. We've also seen people taking the key from a property, either by accident or on purpose when it shouldn't have happened, and also not following those showing procedures as specified on the listing or when entering a property in a status when it's other than active bump or SSP, because we can't, it's very important that everybody is following those showing instructions on a listing and really making sure you've got the right permissions and access and following the information that's also within the listing sheet itself. I see we have some questions that are coming in. Yes, the misuse absolutely erodes the trust of our clients. And I know that we are going to be working on doing more education to our subscribers regarding the misuse and the permissions with the lock boxes, and that'll definitely be important that everybody is on the same page. And yeah, that's the information I have to share today, and I can turn it over to Kathy if there's no other questions.
Terrific. Hi, I'm Kathy Querin, and I'm here to talk with you about complaint number 3, which involves the buyer and seller. Now, we all know that in the sale agreement, there is a clause for mediation and arbitration. So that's what we're talking about here, the home buyer, home seller dispute resolution system. So let me give you the backstory on what is the complaint here, the basis for the dispute. So Oscar finally takes possession of his new home. He did not like the carpet in the loft. They had installed cheap polyester mauve carpeting. So he set about tearing it out, and he immediately discovered unmistakable smell of cat urine. It was obvious the subflooring had been saturated. Oscar immediately called his mother, Dottie, who then contacted the sellers to complain. They reminded Dottie that they told her they were selling the property as is and buyer beware. Dottie found an attorney for Oscar who filed a claim for $45,000 and attorney fees through PMAR's home buyer, home seller dispute resolution system. So 60 days later, they all participated in a mediation conference. The sellers stated to the mediator that they installed new loft in the carpeting at their own expense and that the room smelled fine when they left the premises. Dottie attended the mediation as a witness for Oscar, and she explained to the mediator that she had not seen the loft when she'd taken the listing because there were guests occupying it. And besides, the sellers had an obligation to disclose the condition of the property, and they'd failed to do so. She insisted that the mediator must rule in Oscar's favor and make the sellers pay for new subflooring. The sellers then insisted that the mediator rule in their favor because they sold their property as is. The mediator separated the parties and had a private conversation with the sellers first. explaining that a mediator has no authority to make any ruling or decision. Mediators are there to find resolution to the dispute. So if the sellers were declining to settle with Oscar, they could take their chances in arbitration with an arbitrator who would make a final and binding decision. And this mediator thought that it was likely that the arbitrator would rule against the sellers for concealment and failure to disclose the permanently damaged subflooring. The sellers thought about it and reluctantly agreed that they would pay 70% of the new subflooring. So the mediator made that offer to Oscar, and Oscar accepted 70% of his costs. But the sellers were mad. They were upset that Dottie participated as a witness in the mediation conference in support of Oscar. She had been their original listing broker. How could she then turn against them? And, you know, besides almost losing their cat, didn't she owe a fiduciary duty to her clients, to them, the sellers? And should she even be allowed to provide testimony against them? So those were some of their complaints that you're going to be looking at next. But first, let's talk a little bit about this mediation process. Now, first of all, I'm sure you all know that mediation is for disputes that are over $10,000. That's per the terms of your sale agreement. Small claims court comes into play when the disputes are under $10,000. So so Oscar was in the right venue here. He filed for mediation because he was claiming some $45,000 for subflooring plus attorney fees. And when everybody said to the mediator, we want you to rule in our favor, well, that's not the way mediation works. The mediator works towards the parties finding an acceptable solution. It's up to the parties in the mediation conference. The mediator has no power to impose a settlement. So it's in the parties' best interest if they can find agreement that they can live by, then they make that deal at the mediation table and they come to agreement. And they did that in this case. The buyers or the sellers said, yes, we'll pay you, Oscar, for 75% of your costs. We're not paying those attorney fees. Oscar agreed. He took it, and so the mediation was resolved. But if they couldn't have come to a settlement, then it would have been up to Oscar to file for arbitration through the Arbitration Service of Portland, and that arbitrator would make a final and binding decision. And how that arbitrator would have ruled is anybody's guess, but the mediator's job is to try to shed as much light to all the parties as possible, to help the parties understand perhaps strengths and weaknesses of their positions so that they can make a fully informed decision as to whether or not to settle. Now, in this case, there were no attorneys involved in mediation, but the truth is that most mediations that we see, the parties do have attorneys. So the buyer and the seller have attorneys, and those attorneys help them to analyze their position, because a lot of times at mediation, you'll start to hear more facts that you've never heard before. So there's more and more information that comes out, and as the buyer and seller with your attorney, you'll make a decision as to whether or not you wish to settle. And about 2/3 of the time, our mediations result in a mediated settlement agreement at the table. So there's a decision, there's an agreement, and the mediator will help the parties reduce it to writing, and then you've got a fully binding new agreement going forward. But again, if the parties could not come to agreement, it would then be up to the claimant, in this case, Oscar, to decide whether or not to file for arbitration and let the arbitrator decide. Now, one of the questions that the sellers were mad about was, hey, Dottie originally was our listing broker. Didn't she have a duty to us to protect us? And there she was in mediation supporting her son. Well, think back to what all transpired here in the original case that Mary Williams presented. And as you may recall, when Dottie disclosed that she was writing an offer for her son, her principal broker removed her as the listing broker, which was a really good best practice, not a requirement, because there was full disclosure, but she was removed as the listing broker, and her principal broker substituted another broker within the company to serve as the listing broker going forward, so that Dottie could work with her son, Oscar, and represent his interests. So it was appropriate for Dottie to be there at the mediation. And what's important for you as a Realtor member, if you are ever named in a mediation dispute as what's called a voluntary information source, that's a fancy mediation terminology for witness. If you're ever called in as a witness, like Dottie was here, the very first thing that you should do is talk to your principal broker and make sure that that is an appropriate place for you to be there at the mediation table as a witness. And because what can happen in a mediation case is the parties can ultimately turn against you. You're there at the table and they can suddenly surprise you and say, we are going to amend our complaint and we're going to seek restitution from you in this mediation conference. So that happens. And in fact, mediations frequently are not just buyer and seller. They often have the listing and or selling broker named as a party to the dispute. So an actual party at the mediation table. That's not what happened here. Dottie was an information source. She was a witness for Oscar. Nobody asked her to write a check and be part of the settlement. So that's what transpired here in this case. You can find a lot of information about the mediation and arbitration processes at pmar.org/disputes. You can see that here on the screen, pmar.org/disputes. In fact, we have a whole section on pmar.org regarding disputes. So everything Mary was talking about regarding an ethics complaint, all that paperwork and process information can be found here at pmar.org on our website. The same for the mediation and arbitration processes. So that's what transpired here with this particular case. I'm looking at one comment from Gary Major. She should have had another agent represent her son. You can't unrepresent a client once you have taken on that obligation. Interesting point, Gary. The principal broker replaced her as the listing broker. You know, sometimes a good deed doesn't go unpunished. And we're going to be looking at that a little bit more when we look at the complaints now that were going to be filed with the real estate agency. That's coming up next. So someone else agreed with Gary on that. Yeah, be careful when you're representing family members, right? Disclosure, absolutely, she did that. Would she have been smart to step aside? Possibly so, but that's between her and her principal broker ultimately. So Mary Jane, if you would bring up the next slide, I want to show you some statistics. And again, you're going to have access to these stats, but since 2020, we've had a total of 73 cases come through our dispute resolution program. Again, buyer-seller dispute resolution. This is not ethics. These are typically buyers that have moved in and are seeking resolution of a complaint. And what is the #1 basis of complaint? Big surprise, water. Water is the basis of complaints. It has been since day one in our program. Water is the basis of complaints. 22% of our cases involved a water dispute. And, you know, we just have experienced some incredible rains here in Portland over the last couple of days. And I can guarantee you that if you called me next week, about a week from now or 2 weeks from now, I would tell you that we have received buyer complaints alleging failure of sellers to disclose water problems, that their basement is flooded and the sellers didn't disclose, and now there's flooding again. Neighbors are a good source of information. And in fact, that was part of our complaint here to start with, that the neighbor talked with the sellers and said, hey, I saw the cat run away and there were people in your property, that and the realtor was nowhere to be found. Well, neighbors also say, hey, we'd seen numerous workers here over the years with fixing water disputes. Didn't the sellers tell you about that? So the very first thing that you need to be looking to, of course, is the proper disclosure statement. Did the sellers disclose or did they not? But so water is the number one basis, has been since the beginning of this program. The other basis of disputes that we see regularly, and the number two most frequently cited complaint, is unpermitted work or city violations. So, you know, on your proper disclosure statement, there is a question about, has there been remodeling done and was the work permitted? Buyers are not, or pardon me, sellers are not always truthful with that information. So that's the basis of 12% of the disputes that we've had so far in our dispute resolution program. And another huge basis of dispute is earnest money. So the transaction has failed for whatever reason, and the sellers are not releasing the earnest money. They've gone to the title company, or the escrow company, I should say, and have said, we want our money back. And there's a dispute. So sellers are holding on to money that they believe they're entitled to. Buyers say, no, 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 you did whatever, and we're entitled, you failed to perform, we want our money back. That is another basis for a dispute. Again, your dispute has to be $10,000 or more to be into this process. So that is a frequently cited basis for a complaint. And of course, we have 29% that are just other. They fall into all kinds of categories, but some of the other areas that we see regularly, well, they're listed here. Rescission, where the seller doesn't want to sell any longer, as opposed to specific performance, where the buyer is requesting performance. Or pardon me, the seller is requesting specific performance of the buyer. So those are two more areas of dispute. And roofs are often a matter of dispute, and might they involve water sometimes, oftentimes, but other times it's how many layers of roofs are up there, what was disclosed, has the roof failed, etc. So that's a common basis of complaint. And I can tell you that we also see under other category, we see a lot of complaints about property lines and lines of possession. So that's an area where there's dispute, as well as homeowner associations, maybe documents that weren't provided, or a failure of the homeowners association to properly memorialize pending assessments. So that's a basis of a dispute. And we still see oil contamination issues with leaky oil tanks that were not disclosed. So there are so many different types of disputes that can be brought forward in the home buyer, home seller dispute resolution system. But it's there to protect you as a realtor, to keep you out of the middle of disputes, because typically these are buyer-seller disputes. Buyer moves in, finds a property, talks to the realtor, realtors talk to each other. Ultimately, it's the buyers generally that file the complaint, and then up to the mediator, of course, to try to guide parties to resolution. And again, the type of, we get about 2/3 of our complaints or our mediations that resolve in a settled mediation conference. The rest of them either go away or they go to arbitration. I do see one question. What's the percent on earnest money? I see that you can't see that on your slide. 15% of our disputes during this time frame were based on earnest money. And let's see, I see something else here in the chat from Diana Collin. It's best to get ahead of these problems, stay in touch with your buyers. Could it be as simple as getting the gutters cleaned? Yeah, be a resource. If you drop all communications or shy away, they can blow up and turn into a big dispute. We can mitigate. I agree, Diana. There is certainly an opportunity for you as the realtor to try to help settle, find resolution, not run away from a problem. But again, when you hear a dispute is bubbling up and burbling, what's so important is that you talk with your principal broker. Let your principal broker know that there's a potential dispute pending. Here's the claim. Here's what's happening or isn't happening, and make sure that your PB is involved, because if you do ultimately get named as a party to the dispute, your principal broker needs to know and may invoke your insurance company. So there are a lot of moving parts here to the dispute resolution program. But again, we have a lot of information on PMAR.org. So I urge you, if you have questions about the program, to go to our website. And also I want to give a shout out to our dispute resolution services manager, Susan Schneider. She's been with the organization here with PMAR for over 20 years. And she will help you to understand the processes. She can't render any decisions or give you an opinion on who's right or who's wrong in ethics or arbitration or dispute resolution, but what she can do is guide you to the paperwork and get you down the right path to finding resolution. So Susan is amazing. Yeah, Latasha must have had some experience with Susan. She is terrific. She's a fabulous resource here at PMAR. We're very, very fortunate to have her here on staff. So with that, I am going to turn over the final steps in our complaint here today to your commissioner. And this is your commissioner, Steve Strode. Many of you know Steve, of course, as being the commissioner of the Oregon Real Estate Agency, but hopefully you know that Steve was a real estate broker here in Oregon for many years before he became commissioner. So he knows what it's like to be boots on the ground. So Steve, I'm going to turn off my camera and turn this over to you. Thanks for joining us today.
Good morning. Thank you, Kathy. And sorry about the background light. It just got really sunny here, but okay. Well, good morning. Thanks for inviting me to this class. And so the next part of the process is now this turns into a complaint to the real estate agency. And so unhappy about settling with Oscar and seeing the proceeds from the sale of their house diminish, the sellers decide to file a complaint with the Oregon Real Estate Agency against Dottie and her brokerage. And so their complaint alleged poor brokerage supervision and that Dottie priced their home too low to benefit her son, that they opened the home without permission, left her son and contractor unsupervised, caused them to almost lose their cat, and then that she took her son's side in mediation, which she should have been representing them instead. So is there a poll on this, or am I talking about my process first? Just kind of curious.
There is a poll, and we can go in whatever order you'd like if you want to talk about.
Okay, so do you want to take the poll first, and then I'll talk about our process and what we may have felt here?
Perfect. Yeah, I'll get that.
Okay, great. Okay. So let's take the poll and see if you feel there were violations here. Okay, great. Thanks for chiming in on that. So I'll talk about the process a little bit and kind of how we look at it in the agency. So if a complaint comes in, we will share that complaint with the licensee, then call the respondent, and we ask for a written response. And then when that response comes in, if we feel there's a grounds to consider there may a violation may have occurred, we'll open the investigation. Then the investigator will try to interview all relevant parties, and then the investigator writes up their report, and that gets turned over to a lead reviewer. So the investigator is not making any recommendations, they're simply collecting information in an unbiased manner, take in all the facts, and then refer it again to a lead reviewer. And then if the lead reviewer believes there are no violations, or perhaps just an education letter can be generated, they will close it themselves. If they feel there could have been a violation of licensee law, then it'll get sent reviewed with me, only if it's going to be an administrative action, things like that. So administrative action would be a reprimand, suspension, civil penalty, revocation, something along those lines. So in this case, this is how I would have viewed this one. When it comes to pricing their home, that I don't see a violation occurring here. They were disclosing the fact that it was the son. The list price seemed valid. They opened it up to the market for the entire weekend so they could get highest and best offer. So I don't see a violation here when it comes to pricing the home. And just as a side note, we did write an article in June about the definition of list price. So a seller is expected to list their home for a price they're willing to take on the property. So if they're willing to take $300,000 only, they could not list it for $200,000. That we're not about that. So the first issue about purchase price, I don't see a violation there. The other three, and I think that was reflected in the poll, 94% I think said they found violations. It's the next three that would cause us concern. Opening the home and then almost losing the cat and leaving the son unsupervised. So in ORS 696.301, there are 15 reasons that are grounds for discipline. Things like contract interference, interference with an agency agreement, act of fraud or dishonesty, things like that. Now, the two that often come up in cases like this would be related to acts of dishonesty, which is in subsection 14, or in subsection 15, that is engaging in conduct that is below standard of care. And I think we had general consensus on this, that there were some things going wrong with this. So I could see the violation occurring under below standard of care. Another area would be 696, I believe it's 859, which the real estate licensees have duties as a seller's agent and their obligations to exercise reasonable skill and care. So there's two areas where that might come into effect. So I think there's general consensus, yes, the Dottie did something wrong. So moving on to the next complaint. So I've already talked about this a little bit. You know, Oscar had a falling out with his mother because she told him to waive the inspection contingency in order to strengthen his offer. She said the house was in excellent condition, although when she took the listing, she was unable to view the loft area because the sellers had guests in the room. They did not want them to be disturbed. Oscar trusted her advice, but it had cost him a great deal of time and anguish, and the mediation settlement did not cover all the costs to repair the stinky subflooring. Oscar filed a complaint with the Oregon Real Estate Agency against his mother for failing to protect her own son's best interests. He wanted the agency to make her turn over her commission since she had earned it and now was on a trip to Hawaii. So that's the next complaint. So in this complaint, let's take a poll here. Was Dottie negligent, and are there remedies there? So guilty or not guilty of violating duties of a licensee? Okay, so about 2/3, over 2/3 said guilty. This one, I think I'll sound like a bureaucrat now and say it depends. So this is one where we would try to verify the accuracy of this information. If it's all true, it could fall under a violation of 696-805 subsection 2, where she would advise the seller, I'm sorry, advise a client, I might have the wrong citation here, but it's basically advising a buyer to seek expert advice on all matters related to the transaction that are beyond the agent's expertise. So that's true. This may be more difficult to prove because it could be a he said, she said scenario where Dottie's saying, I never said that, he's saying she said that. So we would look to what's in the sales agreement. How is it disclosed that he was waiving the inspection? Is there other information to look at? Was there emails? Were there texts? Things like that discuss why he's waiving the inspection. Again, this one's tougher because we know currently a lot of buyers are willingly waiving their inspections to make their offer more attractive. So again, this one's tougher. If we can prove that we have enough evidence that shows that she simply said the house is in great shape, go ahead and waive it, that would be a violation. Absence of evidence, this one's a little tougher to decide. The next one is related to covering the costs. Now, I don't know if there's more polls about this. Are there more polls related to restitution and supervision by the PD?
No, that was the last one.
Okay, great. So there's a couple other questions I was given in this scenario, and that was, will the agency investigate the brokerage for supervision or just investigate Dottie? And this one, from what I read, it sounds like the complaint's coming in, a complaint against the broker and a complaint against the principal broker, in which case we would need to open them up simply to ask for a response from both the broker and the principal broker. We don't have enough information here to decide if the principal broker had any violations here, but from the way this is worded, I think we'd open up an investigation against both and at least ask for a response from Dottie's principal broker. The next question was, will the agency make Dottie pay restitution for her son? Because he felt that he had all his added expenses and mom went to Hawaii. So in this case, the agency does not have statutory authority to make respondents pay for restitution when a license has violated their affirmative duties as a seller's agent or those other grounds for violations. So in these cases, if it's a civil matter, we will recommend that the consumer seeks legal advice. And in this case, they have already done it. They've already gone through the mediation process. So we do not have statutory authority to make someone pay. We can assess civil penalties that are limited to several areas only. And that's civil penalties related to escrow activity violations, unlicensed activity, and then for real estate marketing organizations that are not, they're not registered with the state. And in any of those cases, any of those civil penalties, those go to the general fund. They don't go to a complainant or a respondent. They simply go to the general fund. So that would be outside of our authority to make them forfeit commissions. So I think I covered anything. Is there anything in the chat box that I should be aware of? Let's see. Somebody commented not enough information. Sounds like I agree with Mark Wheeler on that one.
Thanks, Steve. I think most of the comments were just chiming in, acknowledging the situation. So nothing really directly about questions. I think there was one more slide that was going to go into some statistics over the years.
Yeah, I was going to share that with you as well, because by statute and rule, we employ a progressive discipline process. So the purpose of progressive discipline is to identify potential violations and correct that behavior, and so that a licensee doesn't make that mistake again. And so this shows what our stats have been the past several years. And if you'll notice a few quick things off the top here. Number one is from the number of complaints we receive every year, most don't turn into any kind of sanctions such as civil penalties or reprimands or revocations, things like that. The bulk of which we issue education letters of advice. That's an ELOA, education letters of advice. And again, that's because we want to educate a licensee so that they don't make the same mistake again. So that's the first step in progressive discipline. This is one area where I think there could be some misunderstanding or just not full knowledge about the agency. These are not public. So we know that everyone reads the RNJ and looks at the last page, which is the administrative actions. ELOAs do not fall under that. So we do a lot of that work in the background trying to educate and help correct licensees' behavior. It doesn't show up publicly. So this helps you understand that, like in 2020, more than a third of the complaints that came in were education letters in response. You can tell also that we don't do a lot of revocations. I'd like to speak a little bit to the 2020 totals. The 2020 totals reflect one anomaly where you may have read in the OREA last year that we had some management change and there were some cases that we had to catch up on. We call them recovery cases. That were left in the queue part of the prior management. So we got caught up on those. So I think that's why you'll see a large uptick in some of these sanctions last year compared to the 2018, 19, and 21. You'll also notice we don't do a lot of civil penalties. Most of those are due to unlicensed activity. Under sanctions limited license, that's where, for example, we might have a principal broker who is found in violation and we put them into a broker category for a limited period of time and take away those supervisory abilities. So reprimands are on here. Reprimand education, that's when the respondent agrees to take more education related to their violation. A good example of that is taking the advanced practices course, because a lot of brokers and principal brokers got their license prior to that being a requirement. And then again, suspensions, revocations. I saw something come up in chat. Is his take on the decline of actions that we are doing a better job of reporting it less often? I don't have a good idea for why the number of complaints is so much less for last year, other than everything else about last year was different. I think I'd wait to see maybe longer term trends. And now the 256 for this year is still based on the first 3 quarters, so we don't know the year in total on that yet. Oh, what's an ELOA again? Education letter of advice. And that is simply, we didn't feel that something rose to the level of offering a reprimand, but we were concerned enough that the licensee should be aware that this could be a potential violation. So again, it's the first step in the progressive disciplinary process, giving somebody basically a chance to make it right before we issue a reprimand.
Thank you, Steve. It looks like you've wrapped that up. Anything else you'd like to comment on? It seems like we have a comment from Kathleen. Seems like a lot of
revocations in 2020.
Yeah.
Yeah. So that also tied to some of this backlog of cases that were uncovered from the prior manager, and we're catching up on those. So it looks like we may have come down really hard last year. That's really not the case. A lot of those cases were older, a little bit older. And then I also did a search before the call today. More than half of those related to property management activities, client trust account violations, misappropriation of funds, but well over half, I think it was, or I should say about half were related to property management activities. And that's one area where we don't often employ progressive discipline like we would with like brokerage issues, because money may have been taken, severe misuse of, severe abuse of trust among property managers with their clients. So we do take a somewhat stronger approach with property managers when money's missing and things like that. They don't get second chances if they're stealing money.
Okay, good information. So thanks everyone again for attending. I just want to thank our panelists again, Mary and Christina, Kathy and Steve. Your input today was really helpful during this scenario and all these different ways that we as agents can grow and be better in our industry. So thank you for that. Lynn, I want to congratulate. So let's go back to the credit hour. If you joined late, this is going to be recorded and you will get an email with the slides. So again, on that, in order to receive your certificate for the 1 hour of continuing education, you will need to fill out and return the attendance form that was emailed to you this week. Again, we hoped you stayed for the whole presentation. That is another requirement for the credit. Attendance forms again are due by the end of next Thursday, October 7th, as a reminder. So if you did not receive the attendance form, please reach out to Mary Jane Manfield. Her email is going to pop up here in the chat in a moment. Lynn, I just want you to know that Michelle will be reaching out to you with PMAR for your comments. And again, no worries about your mic not working. We are just thankful for you and what you give to the community. And we want to, again, congratulate you and Benjamin on your leadership in our community. So I think that wraps it up there. You'll see the email for Mary Jane there at PMAR. And this is the last call out for any questions or comments. And with that, I think that wraps up our presentation today. Have a great day. Looks like the sun is coming out, so enjoy your day and go do great things.